Welcome to our latest deep dive. Today we have a stack of legal excerpts focusing on a 9th April 2026 Supreme Court of India ruling.
Right, the KG Seshadri were the trustees of State Bank of India and another 2026 INSC 333 case.
Exactly. And our mission today is to explore the huge financial and legal difference between just quitting your job and officially retiring, plus why your exact start date matters way more than you think.
Yeah, it's a huge wake-up call for anyone with a workplace pension plan, honestly.
Oh, absolutely. So, to set the stage for you listening, the case in question relates to a former SBI clerk who goes abroad, completely vanishes from work for a long stretch, and then just shows up years later asking for his pension.
After years of unauthorized absence, he literally came out of the blue to ask for a pension. No, demand a pension.
Yeah. Okay, let's unpack this because it's like ghosting a relationship, right? And then showing up years later expecting a birthday present for every year you were away or AWOL. The chutzpah.
That is exactly what it's like. And, well, what's fascinating here is how the court drew a very sharp, unforgiving line. The bank didn't just hold his job open.
Quite remarkable of the bank to keep his position open, notwithstanding his unauthorized absence.
They looked at that unauthorized absence and legally treated it as him quitting, what the court called voluntary abandonment.
Oh, okay, so not voluntary retirement then?
No, completely different. The court's ruling serves as a vital precedent for balancing employee rights with institutional discipline and precise record keeping.
Absolutely. You can't just abandon your post without authorization.
Right. Voluntary retirement, under the bank's Rule 22, requires a formal written request. And that request has to be explicitly accepted by the employer. You can't just disappear.
So the clerk ghosted the bank, which ruins any standard voluntary retirement. But wait, hold on. I'm looking at his employment history here.
Oh, okay. What does it say?
He was hired in 1959. If he left in 79, that's 20 years. But wait, doesn't the employment clock start on your very first day?
You would naturally assume that, yeah. But under the State Bank of India's pension rules, the clock actually starts at confirmation, not the initial probationary appointment.
Oh, really? It starts from the date you were confirmed in the role and not your start date while still on probation.
Yes, because probation is fundamentally a trial period.
Oh, I see.
The bank hasn't permanently committed to you yet.
Right. Okay, that makes sense because the commitment comes after your confirmation.
Right? So the court ruled that the pension clock, which is deferred, earned income, payable for years in service, doesn't actually start ticking until both sides make that official commitment.
Which means anyone listening right now who spent like 6 months or a year on probation, you need to subtract that from your retirement timeline.
Exactly. The time spent on probation is completely excluded. So in Seshadri's case, he was officially confirmed in February 1979.
Okay, that's a great point.
And if you do the precise math from that confirmation date, he completed exactly 19 years, 9 months, and 25 days.
Oh, that is brutal. He missed it by just a couple of months.
He fell agonizingly short of that 20-year statutory threshold. And there was another fallback rule he tried to use. Rule 22 ICI.
Did that work?
No, it didn't, because that requires not just 20 years of service, but also reaching the age of 50 before leaving. And he missed that mark too.
Tough luck. So, lacking the required time and totally missing a formal exit, he tried a legal workaround, right?
Yeah, he did.
He tried to invoke Section 30 of the Industrial Disputes Act to basically force the pension calculation.
Right, which is a big stretch.
It's basically like trying to use the fast track checkout lane. When you haven't even paid for the groceries, you're trying to cash out a benefit you haven't actually secured yet.
Yeah, the court basically said you can't skip steps like that. Think of Section 33C2, like a calculator, not a piggy bank.
A calculator? How so?
Right? It's a tool used to add up money you were already legally owed. You can't use a calculator to prove someone owes you money in the first place.
Okay, I see.
This statute is strictly a mechanism for enforcing an existing right, not establishing a disputed one. So if we connect this to the bigger picture, this ruling heavily strengthens banks against informal backdoor claims.
Definitely.
It proves that benefits tied to long service demand strict absolute compliance with the rules.
So, what does this all mean? Ultimately, it means informal exits destroy your pension rights.
Completely. That's the true moral of this case.
If you want the payout you've worked decades for, you absolutely must protect your benefits by following the formal procedures to the letter. No ghosting your employer, and definitely double check your actual confirmation date.
Yeah, the rules are the rules, and the courts will apply them mathematically because that's all they have to work with. You cannot disguise abandonment as retirement.
Exactly. Which leaves us with this final thought for you to chew on. The Supreme Court distinguishes between voluntary abandonment and voluntary retirement based on how the exit is initiated, the level of adherence to formal statutory procedures, and the resulting eligibility for pension benefits. That's the main takeaway from this legal battle.
Right? It's a huge takeaway.
Because we are looking at a world increasingly dominated by indefinite freelance or contract roles where that official confirmation day may never actually come.
And that's a wrap. Before we go, if you're new here, welcome to the Bloggerian. We cover the real stories across India's pension landscapes, not least MC Singla case and pension updation. So hit that subscribe and bell buttons right now so you never miss a podcast like this one. Until the next time.